power-driven ideologues like him. He has already amassed a body of work that shows how he can and will deliver for the movement that has groomed him for this moment. Judge Kavanaugh has demonstrated a dangerously expansive view of presidential power. The president is not a king, and this is because the Constitution establishes separation of powers and a system of checks and balances to ensure that no arm of government can overpower the others. The framers recognized that particular danger of a Supreme Court without judicial independence. In Federalist 78, Alexander Hamilton quoted Montesquieu saying, quote, "There is no liberty if the power of judging be not separated from the legislative and executive powers." He added, "Liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments." Based on his writing, I fear that Justice Kavanaugh is predisposed to provide the deciding vote on the president's agenda before cases against him even reach the Supreme Court. For example, the Supreme Court has never had to decide whether a sitting president can be prosecuted for federal crimes. It is perhaps more important now than ever in our history to ensure that a nominee to the court can approach questions of presidential accountability with independence and an open mind. Judge Kavanaugh cannot seriously claim to have either on this issue. As a veteran of the Starr investigation in the Clinton White House, Judge Kavanaugh understandably has strong feelings on the issues of civil and criminal prosecutions of sitting presidents. In 1998, Kavanaugh authored a law review article discussing the now-defunct independent counsel statute in detail and recommending changes to the statutory scheme. He argued there that Congress should pass a law prohibiting the indictment of a sitting president until after the president's term in office. But he made it clear at several points that he believes that such a law would codify what to him is already plain in the Constitution, that a president is above our criminal laws while he holds office. His views about presidential accountability did not evolve over time as seen in the various ways he continued to share his views over the years. In 1999, he told a reporter that he doubted whether the Supreme Court got it right in the United States v. Nixon, the landmark case that held that president could not always use executive privilege to escape a subpoena to turn over records in a criminal case. And for those who lived through Watergate, it was the Supreme Court's decision, in that decision, that more than anything else preserved, I think, the stability of the Union and the triumph of the Constitution over partisan politics. It led to President Nixon's resignation. It also showed convincingly that the court could take a decision seriously with respect to the Constitution without considering the political effects. And Justice Kavanaugh believes they were wrong, that President Nixon should have been allowed to defy the court, defy the country, and maintain secret the tapes of his discussions in the White House that ultimately led to his resignation. In 2008, as a judge in the D.C. Circuit, Kavanaugh published another article suggesting policies to improve the functioning of the federal government, which reiterated his support for a law to defer all civil and criminal cases against the president while the president holds office. To be clear, lawyers and legal academics have debated these issues of presidential power and accountability from the founding of the republic. This debate is particularly relevant in light of how easily a governing majority of the president's party can crush congressional efforts to investigate wrongdoing by the president and his administration. Judge Kavanaugh has every right to publish his thoughts for legal academia, but he cannot have it both ways. He cannot spend 20 years arguing that the Constitution forecloses criminal investigations of a sitting president and claim now that he approaches the issue with an open mind. We may soon need clear answers from the court about whether a president can pardon himself and whether he can be subpoenaed, indicted, or otherwise held to account for wrongdoing. If such a case would arise to the Supreme Court, it would be gravely damaging to the court as an institution if the American people were to believe that the president had already secured the votes he needed to win because of his judicial appointments. It's also clear that Judge Kavanaugh comes to this nomination with his mind made up to deliver other important victories to the president and powerful corporate interests at the expense of federal agency autonomy and independence. 2 years ago, Judge Kavanaugh spoke on a panel before a conservative special interest group where he was asked if he could think of a case that deserves to be overturned. After some hesitation, he answered that he would put the final nail in the coffin of Morrison v. Olson, which upheld the constitutionality of an independent counsel who could only be fired for cause by the president. This deserves consideration. When given the chance to name any case he would overturn, Judge Kavanaugh did not think to name any of the most egregious cases from our early history as a nation, such as the now overturned Korematsu decision, which upheld Japanese internment, or Buck v. Bell, which upheld compulsory sterilization of the intellectually disabled. Instead, Justice Kavanaugh made it clear that he would strip Congress of its constitutional authority to protect apolitical public officials like Special Counsel Mueller from arbitrary interference and firing by the president. Just this year, Judge Kavanaugh showed that he was serious. In PHH Corporation versus Consumer Financial Protection Bureau, the full D.C. Circuit upheld the constitutionality of the statute creating the CFPB and providing that its independent director could only be removed by the president for cause. In his scathing dissent, Judge Kavanaugh quoted at length from Justice Scalia's dissent in Morrison v. Olson and made it clear that he would have placed the CFPB director under the thumb of the president. I believe it is safe to assume he would have gone even further in undermining the consumer agency's independence if he had the power to overturn Morrison altogether. This is not the only area where Judge Kavanaugh would deliver long sought-after victories for conservative operatives and special interests. He has also made it clear that he would undercut or even overturn the law of Chevron deference. As this body discussed at length in debate over Justice Gorsuch's nomination, the Chevron case stands for the proposition that when someone when someone sues a federal agency, and a reasonable person could read the statute at issue in more than one way, the court should defer to the agency's reasonable interpretation of the law that the agency is charged with enforcing. Put simply, Chevron prevents big businesses that are trying to escape regulation from pouring millions into lawsuits to second-guess and slow down every piece of a rulemaking process that they don't like. Even Justice Scalia defended Chevron as a reasonable check on judicial activism. But like Judge Gorsuch, Judge Kavanaugh has made it clear in his academic writing that he would overturn Chevron as we know it and systematically tip the scales in favor of well-funded challenges of regulation. In my view, such a major change in the law will put our nation on a path back to the bad old days when companies could pollute the environment, scam their customers, and discriminate against their employees as long as they could pay enough lawyers and get the right judge when a federal agency sues. This would bring us one step closer to the deconstruction of the administrative state that the Trump administration envisions and could severely obstruct future administrations in their efforts to protect consumers, the environment, and those who need a helping hand against the very powerful. I would like to take a minute to return back to the concept of judicial discretion. As I discussed, I've evaluated every nominee for the Supreme Court during my time in this body based on whether I believe the nominee would have an open mind to be able to use his or her discretion to promote equal justice under the law and to safeguard the powerless against the powerful. Upon review of Justice Kavanaugh's opinions, I do not believe that he would. He has routinely sided with employers and big business against workers, consumers, and those seeking to hold powerful interests to account. Two of his notable opinions illustrate the contrast between his treatment of interests he favors and those he does not. In the case of SeaWorld of Florida versus Perez, it concerned a tragic incident at the theme park in which a killer whale grabbed its trainer and pulled her into the water, killing her. This was not the first trainer whom this whale had killed this way. The Department of Labor sanctioned SeaWorld upon concluding that the company knew about the danger this whale posed to trainers and failed to take reasonable steps to lessen the risk. A federal district court affirmed this conclusion, as well as the District of Columbia Circuit Court. Judge Kavanaugh dissented. He argued that it was inappropriately paternalistic for the federal government to regulate matters of workplace safety for entertaining displays, such as killer whale exhibitions. To him, the free market, rather than potentially life-saving workplace safety standards, should decide how dangerous is too dangerous for workers. Compare this narrow view of a worker's right to a safe workplace with Judge Kavanaugh's broad view of an employer's religious right to opt out of regulations. The case of Priests for Life versus HHS concerned an attempt to broaden the Supreme Court's holding in the Hobby Lobby case. In Hobby Lobby, a 5-4 majority of the Supreme Court held that a closely held for-profit corporation could refuse to comply with the Affordable Care Act's mandate that employers provide health coverage, including contraceptives, on grounds that doing so would conflict with the corporation's purported religious rights under the Religious Freedom Restoration Act, or RFRA. In Priests for Life, a religious nonprofit corporation similarly objected to providing contraceptives to employees on religious grounds, but also objected to an accommodation provided under the Affordable Care Act regulations specifically for religious nonprofits. Under the accommodation, the organization could file a form that lodged a faith-based objection to contraceptive coverage, thereby permitting its employees to access coverage through alternative means, not through the company directly. Priests for Life sued to invalidate even this alternative, claiming that filing the faith-based objection was a religious burden because it caused its employees to receive contraceptive coverage. The D.C. Circuit decided against the organization because the organization was wrong, strictly as a matter of law, that the filing of a form caused a change in employees' access to coverage. Judge Kavanaugh dissented, arguing that it should not matter whether a nonprofit's religious objections were strictly correct as a matter of law in order for the objection to excuse it from complying with the law. If the Supreme Court were to adopt this view, it would open the door to dangerous possibilities. In addition to nonprofits, for-profit corporations like Hobby Lobby and others could use religious objections to excuse themselves from an untold number of federal laws, ignoring in the process the religious and practical needs of the employees, the men and women of conscience who work for them, and the consumers who would suffer the consequences. Contrasting these two cases, one showing Kavanaugh's narrow view of an employee's right to a safe workplace, and the other demonstrating his troublingly broad view of an employer's right to opt out of following the law, it becomes clear to me that Judge Kavanaugh would use his discretion as Supreme Court justice to expand the rights of the powerful at the expense of everyone else. Madam President, Supreme Court justices hold extraordinary positions of authority in our constitutional system because they are the only ones with the power to decide that the governing majority, as well as prior justices on the court, got it wrong. The Constitution guarantees every American certain rights that are beyond the reach of the President or a simple majority of Congress to change because the popular majority cannot always be trusted to protect the interests of the minority, particularly when that minority includes the most powerless, alienated, and derided among us. The Supreme Court's work is not automatic. It is not an assembly line. The men and women who sit on the court must use their values and experience in order to reach the conclusions that determine how the Constitution applies to our daily lives. I read Judge Kavanaugh's legal record to show that he would advance a dangerous partisan agenda from the bench. Some may disagree with that conclusion. But the fact of the matter is that the majority is advancing Judge Kavanaugh's nomination in the absence of critical facts that go directly to his character and value. A full and fair investigation, one without predetermined limits, could clear Justice Kavanaugh's name or it could cause him further trouble. But if the majority proceeds now, and he is confirmed, the shadow of doubt will always linger over his position, over the court, and over the United States Senate. Americans will wonder why this nomination was rushed, and the obvious conclusion will be that it served the interest of partisan politics. Rightly or wrongly, that impression will further harden the cynicism and tribalism of those who are inclined to believe that the system is rigged. That doubt in the fundamental fairness and integrity of our government is contagious, and our whole nation suffers as it spreads. Madam President, I believe that we should stop this and show the American people that facts matter and that character matters. And before I yield the floor, I'd like to say one more thing to my colleague. This process and the majority's elimination of the 60-vote threshold for the Supreme Court to confirm Justice Gorsuch last year is now the precedent for future Supreme Court nominations. Democratic members should expect nothing more from a Republican majority. Every senator should think long and hard about whether they are prepared for what could come next as a result of this dissolution of the Senate rules that historically preserved the institution of the Senate as well as the court. The supermajority requirement for confirmation of Supreme Court justice was a vital backstop against the kind of display we have witnessed here in the past few weeks. That's why Democrats kept the 60-vote requirement in place when they were forced by a Republican blockade of lower court judges to fill a host of judicial vacancies with nominees who had cleared committees for district and circuit courts. Now, with a simple majority threshold, any party in power can pack the Supreme Court on party-line votes with nominees like Judge Kavanaugh, who otherwise could never rise to the highest court of the land. I would also note there is no longer any obligation for a nominee to disclose all of his or her records of prior service, nor is there a need to hold fair or impartial hearings. FBI background checks need not be anything more than a mere formality, and nominees have a free hand to appear in campaign-style commercials, disrespect the Senate, and disregard tradition of decorum, so long as they put on a show that plays well with the president and the majority. After all, there is no longer any need for a bipartisan consensus on a justice of the Supreme Court. I've served in this body for over 20 years. I have not been here for all the so-called judicial wars, supposedly beginning with the nomination of Justice Bork, or Judge Bork, rather, who I will remind everyone was defeated on a strong bipartisan vote. But I have been here long enough for the deterioration of this process to know that there is blame on both sides. Democrats in the body have been aggressive when they were in power, but I would also add that scholarly research of many has documented that Republicans have always found yet another way to escalate things even more, resulting in the position in which we now find ourselves. Without some major change in the part of the majority, I hope there is no illusion among my colleagues that we have endured over the last few weeks is anything but the beginning of what is to come. I stand ready, and I think many of my colleagues on the other side stand ready to search for a bipartisan solution and return to a path in which all of us, at least the vast majority of the Senate, have overwhelming confidence in the ability and the dedication of a nominee to the Supreme Court to the Constitution of the United States. And with that, Madam President, I would yield the floor.
Madam President.
Senator from Washington.
Madam President, I come to the floor to speak in opposition to the nomination of Judge Kavanaugh to the Supreme Court. And I want to make a few quick points as we conclude this debate today. And then I want to speak to the people watching who may not believe what the Senate could be headed towards today, who are shocked and angry, frustrated, and hurt. Madam President, first and foremost, I believe Dr. Ford. I believe her when she shared her experience being assaulted by Judge Kavanaugh. I believe her because of what she said and she remembered with 100% certainty. And I believe her despite what some Republicans are trying to use to tear her down, because I know trauma experts tell us survivors may not remember every single detail of these events. I believe Republican leaders and President Trump did everything they could to hide the facts and rush this through because they were afraid of what a full investigation would show. And I believe it is simply wrong to rush to a finish on this confirmation based on that alone. Madam President, I also believe that what we saw of Judge Kavanaugh's temperament in the hearing last week, his bitter partisanship, his rage, his disrespect was absolutely disqualifying as well and will undermine the Supreme Court and erode trust in the decisions that they make. I believe the lack of credibility and honesty he demonstrated in his hearings, which I and my colleagues have spoken about here at great length, is absolutely disqualifying as well. And this isn't just me saying this. We are hearing an unprecedented outcry on this particular point from lawyers and judges and former clerks and the religious community and even Supreme Court Justice Stevens. And Madam President, even setting aside those major issues, before Dr. Ford's allegations came out and before we saw more of Judge Kavanaugh in those hearings, I opposed his nomination because it was so clear he was picked by President Trump for a few key reasons. Specifically, he would overturn Roe v. Wade and erode women's health care. He would gut health care reform and end protections for patients with pre-existing conditions. And he would protect President Trump with his disturbingly expansive view on presidential power, which is particularly dangerous when we have a president under investigation with members of his campaign and administration going to jail and facing indictment. Madam President, that's not all we know about him, but we know those things. And to me, that was enough to make my decision. So I do oppose Judge Kavanaugh. And I hope we can do the right thing here in the United States Senate today. But Madam President, I want to spend the rest of my few minutes this morning making a different point. And not just to my colleagues, but to the people who are watching from home and across the country. Because I am very concerned about the message Republican leaders are sending today to women and girls and survivors right now. The message they are delivering here on the Senate floor and at rallies, through the press, and directly to people. To Dr. Ford and Ms. Ramirez and so many other women, girls, and survivors, these Republicans are saying your voices don't matter. Your experiences, your trauma, your pain, your heartache, your anger, none of that matters. Their message is, so we don't have to listen, we don't have to care, sit down, be quiet. They're sending the message that if you are a woman who was attacked, if you are a survivor, then your experiences are just one more, quote, hiccup to, quote, plow right through on the path to them getting what they want. That if you come forward with your experience, you will be told you are, quote, just mixed up, wrong, lying, or worse. They are sending the message you will be asked why you didn't come forward sooner, what you wore, how much you had to drink, what medication you were taking, if you had any history of mental health issues, why you can remember some things, like the attacker's name and face, not remember others, how he got to the party, how you got home, that you will be mocked and undermined, told to, quote, grow up and waved away. And that's just if they can't find a way to sweep you aside and ignore you altogether. They are sending a message that when it comes to a man who has gone to prestigious schools, who has all the connections, who spent his entire life setting himself up for this moment, it's his experience that matters, his pain that matters, his future that matters, not yours. And Madam President, they aren't just sending a message to women and girls and to survivors. They are sending a message to men and boys too, and that is what frightens me just as much. They're sending a message to them that if they attack women, if they hurt people, they're going to be fine. That they may hear this kind of behavior is wrong, that it's not acceptable, but don't worry, nothing will actually happen to them if they do it. They can grab women without their consent and brag about it. They can sexually assault women, laugh about it. And they're probably going to be fine. They can even grow up to be president of the United States or a justice on the Supreme Court. And Madam President, that is absolutely wrong. So I want to send a very different message today to women, girls, and survivors. Your voices do matter. Your experiences do matter. There are a whole lot of people who are listening to you, who do hear you, who do believe you. And please, please do not give up and do not stay quiet. Because no matter what happens today, however this vote goes, your voices are making a difference. Maybe not to those Republicans mocking Dr. Ford. They may not want to hear what you have to say. Maybe not to President Trump. But with every story that comes out, every new voice that breaks the silence, we make progress. Every father and mother who learns what happened to their daughter or son all those years ago that they had never shared before. Every son and daughter who hears from their mom or dad about abuse or attacks they faced and never talked about. Everyone who hears from a friend, who listens to a coworker. It does make a difference. We've seen that since the Me Too movement started, more and more of that these past few weeks. Stories coming out, helping people understand how pervasive this is, how this kind of violence is something women have been putting up with ages, in silence, unheard, seemingly inevitable, a wall placed in front of every woman and girl in this country. And how, as more and more people have so bravely spoken up, cracks have begun to appear in that wall. Some cracks in how people see the world, people who may never have understood before, who may never have seen the perspective they are learning more and more about now. Some cracks in how companies and institutions need to respond who may have never felt that pressure before. Some cracks in how men and boys are acting, hearing more and more that this is not okay. It cannot be accepted. It will not be accepted. Cracks, cracks, and cracks. But clearly, today we feel the wall still stands. Madam President, if Judge Kavanaugh is confirmed, despite all of the outcry and all of the work done, there will be a lot of people who are angry and hurt. I will be one of them. There will be frustration. There will be tears. I will be joining in them. But there also will be a sense that nothing we can do matters, that if someone like Judge Kavanaugh can get a seat on the Supreme Court, we should just give up, that we can't make a difference, we can't matter. That, Madam President, I will not be a part of, because here is the message I want to send today. Change is not easy. It never is. We cannot give up the fight, and we cannot be discouraged. My vision, my fight, my passion is to live in a country where my granddaughters can walk down the street, go to a party, live their lives, not live in fear, but be treated with respect. I want to live in a country where my granddaughters can go into a job interview and be judged based on what they can do, not how they look. I want to live in a country where you can succeed no matter where you were born, what you look like, or who you love, if you work hard and treat others right. Where you don't have to go to prestigious schools and know powerful people and make the best political connections and go to the right parties. I want to live in a country where if you do all those things and know all those people, but hurt others and treat people with disrespect, you will pay the price. You will face the consequences. Madam President, clearly we are not there yet, but I do believe we're making progress. We may not feel it every day, and today is a day when it is hard, but I believe it. And my message to everyone watching right now is this: don't give up. Don't give in. Don't think your voice doesn't matter. When the Senate failed Anita Hill and confirmed Justice Thomas in 1991, I got mad. I decided to run for the Senate. I wouldn't let anyone tell me I had no shot, and I won. And I see that story repeated over and over. People get angry. They start talking about it. They organize, and sometimes they face setbacks. But they make a difference. They put more cracks into that wall. But when I hear people give up hope, when they tell me they're ending their fight, that they think what they do doesn't matter, I know I'm hearing from someone who isn't going to make a difference. And I think of a line I remind myself all the time. If someone tells you you can't make a difference, it's usually because they are afraid that you will. They are afraid that you will. Because it's true. They're petrified. Because they do know your voice matters, whatever you may think, whatever they may say. So, Madam President, whatever happens today, I'm going to get up tomorrow. I'm going to keep fighting. I'm going to keep fighting for the kind of country I want to live in, for the country I want for my granddaughters, for all of our granddaughters and all of our grandsons. A country where someone like Dr. Ford is believed, where she is not attacked, where someone like Judge Kavanaugh doesn't get rushed onto the highest court in the land. And I really hope everyone who stood up and spoke out, who was motivated by Dr. Ford and so many others, I hope you are all with me today, tomorrow, and for the fight ahead. So, Madam President, I urge my colleagues to stand with us, to vote no today, and to keep working with us tomorrow. Thank you, Madam President, and I yield the floor.
Madam President.
Senator from Michigan.
Madam President, our nation has seen some deeply concerning trends in recent decades. Increased polarization, flat wages for workers, and a growing tribal mindset that makes it increasingly difficult for people to trust each other and our public institutions. We are also seeing a partisan divide that is growing stronger and wider by the day. For example, 60 years ago, about 4% of Americans said that they would be seriously disappointed if their son or daughter married someone from the opposite political party. Today, it is almost half. We are also seeing a growing economic divide. 50 years ago, 9 out of 10 30-year-olds in America were better off than their parents at the same age. In 2010, only half were. It feels like the bonds that make us a cohesive society are fraying, and that life in the United States is growing more unfair for so many Americans. Bringing our country back together and strengthening our bonds with each other will not be an easy task. But without question, the Supreme Court has an unparalleled ability to either move our society forward or to pull us further apart. Unanimous opinions by the Supreme Court to strike down segregation in public schools, affirm the right of criminal defendants to an attorney, and to rein in the use of executive privilege by President Nixon show the ability of ideologically diverse judges to agree on what is fair and what is right. But the Supreme Court as an institution is far, far from infallible. The same institution that just 3 years ago made marriage equality the law of the land also upheld internment of American citizens of Japanese descent while our parents fought to liberate prisoners held in German concentration camps across the Atlantic Ocean. The same institution that gave American women the right to make decisions about their own reproductive health in Roe versus Wade denied citizenship to African American slaves in the shameful Dred Scott decision. Some of my colleagues have said they have confidence that Judge Kavanaugh believes in Roe versus Wade and that it is the settled law. I hope they're right, but I seriously doubt it. I think that if confirmed, Judge Kavanaugh will spearhead the continued erosion of rights for American women, and if given the chance, will vote to overturn this settled precedent. Lots of talk in Washington about the Supreme Court centers on precedent or power or procedure. But, Madam President, I would argue voting for a Supreme Court nominee is fundamentally about people. In making a decision on how I will vote on a Supreme Court nominee, I ask two questions. First, how will the nominee serve the people of Michigan? And second, how will the nominee serve the nation as a whole? And now more than ever, I think we need our Supreme Court not to be just fair. We also need Americans to truly believe that the justices that make up the Supreme Court are fair and capable of dispassionate deliberation. No human being, of course, can be entirely impartial or without bias, but we need Supreme Court justices who are able to understand their biases and set them aside for the good of the country. What we need is fairness. What we need is trust. Our fraying social fabric can only be rebuilt by trust. Trust in our institutions, trust in each other, and trust that our courts will give every American a fair chance in an era where corporate profits are ballooning to record levels. but 40% of Americans don't have the savings to cover a $400 emergency expense. A breakdown of trust undermines our democracy. The farther and faster we retreat to our partisan tribal corners, the harder it'll be to ever meet again in the middle. While Americans expect partisanship from their elected officials, they expect better from our judges. Our founders created a co-equal branch of government dedicated to fairness, and that was the Supreme Court. But unfortunately, when I examine the record of Judge Kavanaugh, I do not see an open mind. I do not see fairness. I see a partisan ideologue who will do judicial backflips to rule in favor of large corporations, the powerful, and the elite. When the Supreme Court conducts its duty to advise and consent on Supreme Court nominees, we often talk about methods of constitutional interpretation. Some judges are textualist, some are originalist, some are pragmatist. I believe Judge Kavanaugh is a corporatist, pure and simple. He starts with the outcome that corporate executives would want, and then he works backwards. I believe this is the unifying theme of his rulings over the past decade. Let's take a moment to review his record. Judge Kavanaugh sided with big polluters when he wrote that the Environmental Protection Agency could not enforce their good neighbor rule. This common sense rule simply states whose states with air pollution that blow across their state lines to bear some of the responsibility for those downwind emissions. The good neighbor rule is one of the best ways to crack down on sulfur dioxide, a noxious pollutant that has created a public health crisis in Detroit, with childhood asthma rates almost 40% above the national average. More sulfur dioxide in the air means more children in hospitals and fewer children in the classroom. Judge Kavanaugh substituted his own values and judgment for the decisions of Congress and the EPA, but fortunately, even conservative justices on the Supreme Court voted to overrule him and allow the good neighbor rule to stay in place. Judge Kavanaugh apparently does not believe in good neighbors, and he also does not believe in good bosses. He has consistently ruled against workers and their interest every chance that he gets. He wrote a dissent saying that companies can simply walk away from collective bargaining agreements made with their workers by just creating a spin-off, a non-union company. He ruled that companies can call the police to prevent workers from exercising their right to peacefully picket. For Judge Kavanaugh, the First Amendment right to speech and assembly comes second to a corporation's bottom line. This is the judicial philosophy that the Republican majority is just hours away from elevating to the highest court in the land. Based on a review of Judge Kavanaugh's rulings, it will be clear that if something is good for consumers, he will find a way to oppose it. For example, Judge Kavanaugh sided with large telecom corporations over Michigan families, startups, and small businesses when he wrote a dissent to gut net neutrality protections. Judge Kavanaugh sided with payday lenders, financial fraudsters, and global megabanks when he ruled that the Consumer Financial Protection Bureau was unconstitutional. Not only does Judge Kavanaugh always rule directly in favor of the largest corporations and powerful special interests, his rulings show that he wants to further tilt our campaign finance system in their favor. He has spoken out and ruled in favor of unlimited political spending in federal elections. And in 2011, Judge Kavanaugh authored an opinion that would allow foreign nationals, not Americans, foreign nationals to spend unlimited, yes, unlimited money on issue ads in American elections. Madam President, if you like dark money undermining our free and fair elections, well, Judge Kavanaugh is definitely your guy. I think that Judge Kavanaugh genuinely believes that money is speech and that corporations are people. To him, Americans are only an afterthought. Madam President, I know many Americans are wondering whether Judge Kavanaugh will look out for their best interest if confirmed to the Supreme Court. I hear it all the time as I travel across Michigan. To my fellow Americans, I would say this: if you enjoy breathing clean air, if you have a boss, if you care about not being defrauded by financial bad actors, or if you care about a woman's right to choose, Judge Kavanaugh will not be providing the fairness that you seek. Like many Americans, I followed closely the testimonies of Dr. Ford and Judge Kavanaugh before the Senate Judiciary Committee. And as I watched Dr. Ford, I didn't see a partisan ideologue motivated by politics. What I saw was a woman speaking with credibility, with earnestness, and incredible bravery. As I watched Judge Kavanaugh testify before that same Judiciary Committee, I saw something very different. I didn't see the temperament and humility we expect from a Supreme Court justice. I saw rage and I saw entitlement. I didn't see a thoughtful legal mind bound by precedent or tradition. I saw a partisan political operative cloaked in judicial robes bestowed upon him last decade by a Republican majority flexing their political muscle. I didn't see an umpire who wants to call balls and strikes. I saw a man who believes that he is the league's commissioner, a man who thinks he should have the power to rewrite the rules of the game to help his powerful friends. I didn't see a man committed to fairness and building trust. I saw a man committed to consolidating power and scoring political points. And I saw a man whose fluid relationship with the truth is beneath the United States Senate and beneath the United States Supreme Court. Today, more than ever, Americans need trust, and we need fairness. Judge Kavanaugh's confirmation will provide only more division in our country and cast a cloud over the decisions of the court for years to come. Madam President, I urge my colleagues to oppose Judge Kavanaugh's confirmation and start over with a nominee worthy of our Supreme Court. Madam President, I yield the floor. Suggest the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Last week, I joined millions of Americans in watching Dr. Christine Blasey Ford and her powerful testimony before the Senate Judiciary Committee, in which she credibly presented serious and deeply disturbing allegations of sexual assault. I have deep respect for her strength and the courage she has shown in coming forward and putting her own safety and that of her families on the line to do the right thing. To me, Dr. Blasey Ford was honest, and I believe her. I supported the call for the White House to reopen the FBI background investigation of Judge Kavanaugh. Dr. Blasey Ford did too. However, in his testimony to the Senate Judiciary Committee, Judge Kavanaugh repeatedly refused to support such an investigation by the FBI. It is clear to me that the White House and the Senate Republicans severely limited what could have been a full and independent review by the FBI of the credible allegations against this Supreme Court nominee. The fact is, the White House and Senate Republicans would not allow the FBI to interview Dr. Blasey Ford, Judge Kavanaugh, and a number of witnesses who came forward publicly. That is simply wrong. It is also wrong to be moving forward on a Supreme Court nominee who so clearly lacks the honesty and judicial temperament that we would expect of someone serving on our nation's highest court. Let us not ignore what we all witnessed at last week's Judiciary Committee hearing. We saw a stark contrast between two witnesses. Dr. Ford was honest, credible, respectful, and thoughtful. On the other hand, Judge Kavanaugh was not honest about a number of things he was questioned about, and he did not provide truthful testimony. What he did provide were aggressively angry political attacks that prove that he lacks the judicial temperament to serve on America's highest court. Even before Judge Kavanaugh's recent hearing, I did not believe that he would be an independent judge. Powerful special interests in Washington hand-picked him and have used their massive dark money resources to push his nomination forward. I can only conclude that Judge Kavanaugh would work for them and not the people of Wisconsin or our nation. It is no wonder that Judge Kavanaugh is the choice of these powerful and wealthy corporate special interests. They want to ensure that they maintain the majority on the Supreme Court that will rule on their issues and in their favor. As my colleague and Judiciary Committee member, Senator Whitehouse, has described in great detail, since 2006, the 5 conservative justices have joined together 73 times as a bare majority in 5-4 rulings in favor of big special interests. These decisions have turned back progress on voting rights, environmental protections, and have allowed corporations to discriminate against workers. Judge Kavanaugh's record shows that he will advance this troubling trend when the people of Wisconsin need a fair, impartial, and independent Supreme Court justice who will stand up for them, not just the big, powerful special interests. At a time when so many in Washington are working to overturn the law of the land that helps provide affordable health care to 133 million Americans with pre-existing conditions, including more than 2 million Wisconsinites, we cannot afford a nominee who would serve as the deciding vote to take us back to the days when powerful insurance companies wrote the rules. The president vowed to appoint judges to the Supreme Court who would overturn the law of the land, Roe versus Wade. And I take him at his word. Judge Kavanaugh is his choice for a lifetime appointment that would turn back the clock on a woman's constitutional right and freedom to make her own health care choices, including access to birth control. I also have serious concerns about Judge Kavanaugh's belief that a president should be protected from investigations and subpoenas and indictments. We have an ongoing national security investigation by the special counsel looking into Russia's attack on our democracy, criminal conspiracy, and potential obstruction of justice. Particularly after his highly partisan testimony before the Judiciary Committee, I do not trust Judge Kavanaugh to provide the independence that we need on our Supreme Court at this time. When Judge Kavanaugh was nominated, I reviewed his record and opposed his nomination because the stakes are too high for the American people. They do not want a Supreme Court to advance a political agenda, to overturn the law of the land on health care for people with pre-existing conditions, women's reproductive health, and the constitutional rights and freedoms of all Americans. I truly wish I had been granted the opportunity to discuss these important issues with Judge Kavanaugh before this vote. But after 7 requests to the White House for a meeting with this nominee, they did not grant me the opportunity to talk to Judge Kavanaugh. The people of Wisconsin need a fair, impartial, and independent Supreme Court justice. Based on everything we know, I do not have the confidence that Judge Kavanaugh would be that justice, and I will vote no on his confirmation to the United States Supreme Court. I would ask for a quorum call.
Clerk will call the roll.
Mr. Alexander.